In the world of luxury, few names carry more power than Hermès, and few products are more iconic than the Birkin bag. So, when digital versions of Birkin-style bags began selling online for thousands of dollars without Hermès' permission, the fashion world, the tech world, and the legal world all stopped to watch. This wasn't just about handbags. This was a trademark war over the future of brands in the digital age. This is Hermès versus MetaBirkins. For decades, the Birkin bag has represented exclusivity, craftsmanship, and status. Hand-stitched, limited supply, often more valuable than gold. Hermès didn't just sell bags, they sold scarcity. And their trademarks protected not just the name Birkin, but the brand identity built around it. To Hermès, the Birkin wasn't fashion. It was a cultural asset. In the early 2000s, NFTs exploded into mainstream culture. Digital art, digital ownership, digital scarcity. Artists and creators rushed in, including one digital artist who launched a project called MetaBirkins. The NFTs featured colorful, furry, stylized digital bags inspired by the Birkin, and they sold for tens of thousands of dollars. No physical bags, no affiliation with Hermès, but a very familiar name. Hermès did not see MetaBirkins as art. They saw it as trademark infringement. From their perspective, the MetaBirkins name was riding on decades of brand equity, confusing consumers and diluting the Birkin trademark. Hermès issued legal warnings. The artist refused to stop. And that's when the lawsuit began. Hermès sued, arguing that trademark law still applies, even in digital spaces. The defense claimed MetaBirkins was artistic expression, a commentary on fashion, consumerism, and luxury. The question before the court was unprecedented. Do trademarks protect brands in virtual worlds? Or does digital art override trademark rights? In 2023, a U.S. jury delivered a decisive answer. They ruled in favor of Hermès. The court found that MetaBirkins infringed Hermès' trademarks, misled consumers, and unlawfully profited from the Birkin name. The artist was ordered to pay damages and stop using the MetaBirkins branding. Trademark law had officially entered the metaverse. This case wasn't just about luxury handbags. It set a precedent. Brands realized their trademarks didn't stop at physical products. Digital assets, NFTs, virtual goods, all were now subject to the same legal protections. Fashion houses, gaming companies, and tech startups all took notes. The digital frontier was no longer lawless. Hermès proved that strong trademarks don't fade with technology. They evolve with it. The case sent a clear warning. You cannot build a business, physical or digital, on someone else's brand identity. Art has freedom, but trademarks have boundaries. This war highlighted a truth many businesses overlook. If you don't actively protect your trademarks, someone else will use them, often in ways you never imagined. Digital markets move fast, and brand misuse spreads faster. That's where Patent Profiler comes in. We help businesses understand, monitor, and protect their trademarks across physical products, online platforms, and emerging digital spaces. Because your brand doesn't just exist in the real world anymore. Patent Profiler, protecting identity in a world without boundaries.